I'm gonna get this movie on his side. I'm trying. I can't get the top. Okay, here we go. I'm gonna leave. I can't get unmute. I can't hear nothing. Do you have to unmute it?
Not on your phone. There's more. I don't know.
Mr. Henry? Mr. Henry, can you hear me? Where's the volume?
What is it? Anything?
Usually there's.
Yeah, one of those. Okay, do the other one. Do the other one. Okay, now see.
We are never. Mr. Henry? Hold on tight. Are you Mr. Henry?
Yes, sir.
Okay, hold on one sec. We're having some technical issues.
Okay.
Okay, yeah. This is that.
Bro. I don't know. It failed. I couldn't catch.
Vega here. McAdams. You come on. You come on. You touch the park. Is anybody else here? You want to raise your right hand, man? Do you swear affirm the testimony that you give in this case, the truth, all truth, nothing but the truth? Oh man, you're yeah, you're the petitioner in this case, and it's everything, man. Your petition for divorce is a straight right to the best of your knowledge. You're asking the divorce to be right. I'm prepared to grant the divorce. You have your hand there, unless you're just wanting to lay it somewhere. Do you have a final decree? The final decree of divorce. It should be. No, it's just the petition. You haven't, as all you see. Yeah, you'll need to bring me a final decree of divorce. Okay. I'm not sure where you had this. Yeah, I mean, I'm not sure where you prepared this. Okay. Yeah, you'll probably need to go there or go wherever and get a final decree of divorce. Okay. Yeah. All right. You're divorced, but I need that order. Test. Test.
Testing 1 2. Testing 1 2. Test 1 2. Test. Test. Okay. That's because he's got his mind. This all this well, but they're saying a little bit louder than something. What do you want me to hook his or these into his computer so that it's fine? Well, when you don't have to get the person just playing across the internet. Even when we were connected
Mr. Henry,
Yes, sir.
you want to raise your right hand? Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Sir, you're Mr. William Ray Henry.
Yes, sir.
You're the petitioner in this case, is that correct?
Yes, sir.
Um, you had Miss Robinson served by citation, is that correct?
Yes.
Citation by publication
Uh-huh.
or by posting it? Yes, posting.
Yes, sir.
Is everything in your petition true and correct?
Yes, it is.
And you're asking the divorce to be granted?
Yes, sir.
Okay. Divorce is granted, sir. I'll just need a final decree of divorce. You can get that to the court.
Okay, thank you so much, sir.
All right, sir. Good luck to
What
you.
do I have to do to bring that up there?
I'm say that one more time.
Sorry about it. So just bring the decree up there just for copy.
Yes, yes. Just between 8 and 5.
Okay. Yes, sir.
Okay. Have a good day, sir.
You too.
Bye bye.
I don't know how to do it. Yes. Oh, 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 hey, boo, mama hitting the dance with. Where you at, baby? Oh.
Sir, you're divorced. I guess you can begin the celebration.
Okay.
Have a good day.
You too.
Just leave, baby.
Yeah, I don't know. Okay. He heard us. He said you could go, what's the
All right,
name?
Mr. Henry, I'm going to put you in the waiting room, or you come up here. We'll meet then.
Okay, sir.
Have a good day.
You
We will have no celebrations in the courtroom. You can sit down if you need to.
No.
Is there anybody present on the marriage of Miguel Vega and Jessica Vega? Doesn't look like it.
Testing, Judge. Testing. Testing. Testing 1, 2.
See, that might be on. Okay. Thank you for How can we do that? Because he uses this.
Testing 1, 2. Testing 1, 2. Okay, so right now.
Hello, can you hear me? I don't know, we might want to start Docket and do this later. Yeah, because they're going to be.
It's on mute.
Okay.
There we go.
All right. This is set for trial Monday morning. Is that correct? And it's my understanding y'all want to do a prove up of some relinquishments of parental rights. Okay. All right. Okay. All right. Well, you may proceed. And you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God. You can have a seat. Actually, up there because of the sound, it may help. You may proceed.
The focus of being personally. In that case, in that position, are you familiar with the facts of this case? I am. The partner and the mother in this case, Melissa Macy's, have entered into a settlement agreement. Is that correct? That's correct. Am I correct that the agreement has been filed with court? Yes. Am I correct that the agreement provides that the mother, first of all, will execute a relinquishment of parental rights with respect to the child? Yes. It's also part of that agreement that the department has agreed to during the time that the department has a permanent management conservatorship of the child and prior to the adoption of the child, the department has agreed to provide the mother once every 6 months, at least one photograph of the child and a written update regarding the child's well-being and health. That's correct. And also during the same time period, the department agreed that they would provide an address to the mother and she would provide an address to the department where the mother can communicate in writing and send the photographs and presents to the child at the agreed address. The department would make up to provide those and to the child. Yes. In addition, in the event of termination of the seat information, the department has agreed that they will make efforts to find an adoptive family. They will also agree to the same terms of the same sort of contract with the child and the family and the mother after the adoption takes place. Yes. And it's also part of the agreement that the mother has been advised that the department cannot guarantee that the adoptive family will agree to those terms. The department is not in a position to guarantee that if the department cannot find a family, it will make that agreement. But can find an appropriate adoptive family, that the failure of that family to make that sort of agreement will not be grounds for the mother to revoke her understanding the challenge of adoption or determination. The mother has also executed the relinquishment of parental rights as described in the agreement. Is that right? Yes. And that's been filed with the court, then, is that correct? Yes, it was filed. Your Honor, we would offer that relinquishment as P1.
As far as the in-person attorney, any objection? None from Ms. Basnett. Ms. Keithley or Ms. Watkins, any objection to admission of P1?
No, Your Honor.
None from Ms. Watkins. Ms. Keithley, do you have any objection?
No objection.
It's admitted.
custody.
Any questions?
Yes. Ms. Lee, are you aware that my office has provided with where the mail needs to go based on the agreement?
Yes, I'm aware.
Is there anything else the department needs in order to ensure that the department provides the updates and pictures?
Nothing at this time, because we haven't addressed it for months.
And are you aware of the execution of the relinquishment that happened yesterday with my client?
Yes, I am.
Are you aware of any information that might suggest she was coerced or forced into signing the relinquishment? Do you believe that she signed the relinquishment freely and voluntarily?
Yes.
With the settlement that you entered into with my client, that was offered after the department was aware that she wanted to relinquish her client, correct? So this was not done in exchange for her relinquishment, is that correct?
That's correct.
Now, in order for the court to grant this, there has to be evidence about the best interest of the child, is that correct?
That's correct.
Why does the department feel like the court should grant the termination of my client's criminal rights as far as the best interest of this child?
At this time, our officer has, is a baby that has a lot of issues that are going to be ongoing in his life. And we feel that he needs to be replacement.
Able to select your client? I got questions for Albert, or is she in the other?
I don't know. I'm still in my 9 o'clock hearing.
Sorry.
We just, at this time, we have to be part
Do you believe that my client will recognize that she was criminal rights? Was she able during this case to demonstrate that she followed those needs for the special child? So are you asking the court based on the testimony today to accept my client's resignation and grant and allow the order to take from her rights?
Ms. Watkins, do you have any questions of this witness?
No, Your Honor.
Ms. Keithley, you're here now. Okay. Do you have any questions in person? Okay. Anything further from Mr. Means?
Yes, Your Honor, just one brief question. Ms. Lee, also treated the stipulated settlement agreement that the mother signed. She also agreed at that time to the termination of the best interest of the child.
Yes.
I have no further questions.
Any other questions from counsel? Okay. You may step down. You may call your next witness. Okay. If you want to raise your right hand, do you swear or affirm the testimony that you give in this case with the truth, the whole truth, nothing but the truth, so help you God? You can have a seat. You may proceed.
Working with this case while the child and you heard the testimony this morning about the settlement agreement with respect to the mother and
I did.
the consequence of this investment.
Yes, I did.
Counsel, there any objection or opposition to this statement?
Yeah.
Miss Watkins, any questions of this witness?
No, Your Honor.
I said that. Any other witnesses? Before I go make a ruling, Ms. Bassett, do you have any witnesses to call? Ms. Keithley, Ms. Watkins? None?
No.
All right, based on the testimony I've received, the evidence that's been admitted, I'll find that the relief that's being requested and that's been agreed to is in the best interest. Find that the termination of parental rights of the mother as to Elijah Ortega is in his best interest. That she has executed an affidavit of relinquishment, and I'll sign an order to that effect when it's presented. Anything further? And so the agreement then is to Y'all were going to come back on the father at some later point.
Yes, Your Honor. That's Ms. Watkins. Yes, Your Honor.
Yes, sorry. Ms. Watkins is right here in front of me on the screen.
And Your
So
Honor,
this-
I will represent to the court that we have signed a similar settlement agreement, both myself and the respondent father. He has been a little difficult to get in touch with. I'm hoping that I can get in touch with him between now and Monday for us to do a similar prove up on Monday and get him in to sign the relinquishments. But in the event that we're unable to get that accomplished on Monday, we're in agreement with Ms. Keithley's motion for continuance. And we've also indicated in our motion to appear remotely, my motion to appear remotely, that the father would withdraw his jury trial demand to take it off the jury trial docket for Monday. So really, I guess I'm just kind of unclear as to whether you want us to try to appear on Monday or whether you have another jury trial going and want to reset it for a later date.
Yeah. So the continuance that was presented to the court yesterday afternoon, it was not very clear to me, but that was an agreed continuance to continue the trial proceeding. Is that correct?
I just agree to continue, yes, the trial proceeding, but I don't know that this will now be a necessity for a trial proceeding, at least a jury trial, which on our jury demand. I suppose there was.
Yeah, you were right, but yeah, if your client's withdrawn the request, then I think you need not appear nor anybody on Monday, unless you're just bored. Okay. Okay. Yes. Yes, you're discharged as counsel of record for your client, but not you, Ms. Keithley. All right. I'll sign the order when it's presented, and that concludes this hearing. Thank you all.
Thank you.
Y'all have a good day. Ala Doobie, Booty, Ala Booty.
Yes, Your Honor. Matt Morris for the defendant, Germania.
Okay, yeah, I've got you here on the Zoom. Then I've got Mr. Polk here in person. So we'll try to get through this. Oh, Mr. Morris, can you speak again?
Yes, Your Honor. Matt Morris for the defendant, Germania.
Matt Morris. Is there anybody else on this hearing?
Yeah, I'm with the McGuire firm, and Shane McGuire was the named counsel on this. I'm just one of his associates.
Oh, okay.
Yes, Your Honor.
but I mean, you're the only counsel on this case this morning.
Yes, Your Honor.
Okay.
I'm on here, Your Honor. I'm sorry, I just got here because I didn't have the link.
Oh, yeah, we're not on that case. We're not on your case yet. We're on another one.
Oh, okay. Oh, I feel better now. Okay.
No, we've had a little technical issues. We're trying to do a hybrid hearing and it's not really working out too well. But we'll figure it out. So. Okay. We will go on the record in cause number D19-28084-CV, case styled Aladabi Booty. Okay. Whatever you said, Mr. Pope, I'll agree with you. Versus Germania. I have James Pope representing the plaintiff. I have Matt Morris present for the defendant in this case. And this is set for trial this coming Monday morning, unless I'm mistaken. Is that correct?
That's correct, Your Honor.
Hold on one sec. Can you hear Mr. Pope, Mr. Morris?
No, Your Honor.
I don't.
Can you hear me now?
I can hear Mr. Polk faintly, Your Honor.
Okay. I don't think we can go off the record. Mr. Pope, would you mind going into the jury room and being on Zoom? Maybe be easier, because we thought we had it set up where. I mean, I know you wanted to be here in person, but it may make it easier. We're still working on doing a hybrid hearing. Working. Not going so well. Yes. I can't imagine doing it remotely. Cannot imagine. I can't imagine that going over here with our internet, or lack of internet service around here, or Wi-Fi, whatever. Stranger things have happened. Did they have a constable or a bailiff with each jury member at their house?
That's
Wow. Okay. We'll come out of recess, and I've got Mr. Polk now present through Zoom in the jury room. So, Mr. Polk, can you hear me?
Yes, Your Honor, I can hear you.
All right. And Mr. Polk, you were talking, and then that's when we led us to have to recess to make sure Mr. Morris could hear you.
Thank you.
You can start over again.
Yes, sir. What I was saying was I had difficulty getting in touch with Mr. Al-Hajabudi. And I finally, after several letters to him, he contacted me yesterday and informed me that he was ill and that he had an infection and he was taking medication for it.
Okay.
So I
would like to make an oral argument for a continuance because I'm not sure he'll be available on Monday.
Okay.
Mr. Al Jabuti is like 76 years old. He has a number of health problems, but we do feel that the infection, once it's been treated, he'll be available.
And so
he said it was a kidney infection.
A kidney infection.
That's what he said.
All right. Is well, Mr. Morris, do you have a response or?
Yes, Your Honor. I would ask that the court note that this is the second time we've tried to come to trial on this one. My office has had difficulty contacting Mr. Polk's office regarding this case. We've offered good money to settle this and they've not accepted. And so we're ready to try this one, and we've been ready to try this one, Your Honor.
I would like to respond. You have no problems getting in touch with me. I'm at the same place, been there with the same number and all that information for over 40 years. So if you're saying that you had difficulty getting in touch with me, I dispute that. And why wasn't it tried before? I mean, I'm not sure. You're saying that we caused it not to be tried before? Is that what you're trying to allude to?
Yes.
No, I don't think that's true.
Okay. Leslie is not able to hear what Mr. Polk said. Can you state that over again?
Okay. I guess what I was saying was, you said that they had tried to have this trial before, and I said my statement was it wasn't our fault that you didn't go to trial before. But and also I said his allegation that he'd had difficulty getting in touch with me. My statement was I've had the same phone number, same email, all that information for over 40 years. Well, I don't know about the email for 40 years, but I'm right here. You have had no difficulty getting in touch with me. That's false. And as far as I know, this will be our first formal, continuance on this case.
So your client, he's not able to appear even remotely at this time?
Maybe we could get him remotely. That may be possible. That may be possible.
Let's recess and see if you can get him to call in, or he doesn't have to use a video. I mean, you'll be able to you'll know his voice, I'm sure, if you've dealt with him. So let's see if he can call in and maybe make things a little bit better, so I can kind of have a better idea of how to proceed on the motion to continue. But if you want to contact him,
I will attempt to contact him. As I told you before, I've had difficulty getting in touch with him because he lives out in a rural area. He's 70 some odd years old, and I'm not sure what technology he has, but I will attempt to get in touch with him.
Okay. While you're doing that, I'm going to go to one more. I have another motion that was set for 9 a.m., a motion to quash. So I may do that one while you're trying to get him in there. So if y'all want to, you can just mute yourselves or whatever, and then I'll wait to see if anybody calls in. And then when we're done with that, I'll come back to this. I hate to put y'all waiting, but I might as well accomplish one thing while I'm waiting. So
I understand, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Stone, are you with the plaintiff?
But it should. Yes, Your Honor. Can I put you on hold for just 1 second?
Sure.
I'm trying to do two hearings at once.
I
Okay,
understand.
the judge is calling me in the other case,
Go ahead, sir.
so I'm gonna have to log off.
Okay, not a problem.
Okay, I'm sorry, Your Honor. I'm good to go.
Okay.
Good morning.
Mr. Stone, I remember you from the last time we were here, but you're with Mr. Garcia's office?
Yes, Your Honor.
And,
Can you hear me okay?
Yes, sir. Miss Gruing, you're
Yes.
here. And then anyone else?
Yes, Judge, I'm John O'Haron, the Sheehy Loveless firm over in Waco. I'm here on behalf of the uninsured motorist carrier, Geico.
Okay. Okay, we will go on the record. Oh, did you get everybody's names? All right, we'll go on the record in D20 29356-CV Canella versus Sanchez. I have counsel for parties present. This is a motion to quash. And I don't have the file directly in front, it's behind me, but in the interest of time, whose motion to quash is this?
Both defendants.
That's right, Your Honor.
Okay. All right. Is it a joint motion or different motion? What?
We filed separate motions, Your Honor. I think the notice that the plaintiff issued was actually for the named adjuster of the liability carrier, which is the carrier that is in Ms. Gruing's interest. So I think probably her motion and then my motion is kind of a backup.
Okay. All right. Well, Ms. Gruing, you may proceed.
Thank you, Your Honor.
Your Honor,
This is a motion.
Your Honor, if I might interrupt, I know that it's their motion to quash. I requested the hearing on this because this is really a simple factual matter, and neither attorney has given us any cooperation with setting depositions in this case. So we noticed it, and that's why it's quashed. So I might be able to short circuit some of this. I can tell the court that I have attempted on many occasions. My staff, Denise Torres, has reached out to both attorneys' offices for agreements and has been ignored. So that's why we're here today, Judge. I requested this hearing because I think that these motions are unfounded.
Do y'all want to? Let me put y'all in the breakout room for a moment, okay? It probably is mold. I've been noticing a musty, moldy smell for about a week or two. Yeah. There's no telling what we're hearing. I mean, what we're smelling and, huh? Yeah. Mr. Pope, were you able to get in touch with your client?
That's what I wanted to say. I've called him and I've texted. And talked to Lolita, and that was one of the problems we've had all along, is that telephone communication with him has been difficult.
Yeah, let's go back on the record and calls number D19 28084-CV. And so Mr. Buck, you're not able to get in touch with your client? I mean, does he live here in Navarro County?
He lives in Navarro County. He lives kind of out on the rural, I see it's a county road, so I assume it's rural. I have not, yeah, he lives here in course. He lives in Navarro County for sure.
Okay. What pretrial motions and motions in limine do we have? Were they pretty standard?
I think they're pretty standard, as far as that goes.
Yes, Your Honor. And our motions in limine are on file with the court. We filed on the 14th of June.
Okay. Have y'all had an opportunity to discuss those motions?
We have not.
We've not, Your Honor.
Let me put y'all in a breakout room, and then I'm going to go back to the other one. Then I'll make a ruling on the motion to continue.
Thank you.
Thank you, Your Honor.
But I bet the plaintiff can get here Monday morning. It's kind of what I'm thinking, whether he appears remotely or however. So, but I'll put y'all in the breakout room.
Thank you.
Thank you, Your Honor.
Thank you. Okay, it's up there. Room 2. Should be.
Well, I don't see it. Now I do. I do see it now. Thank you.
Okay. We're switching back and forth, so hopefully I don't. Okay, we'll come out of recess in D20 29356. And y'all had an opportunity to talk.
Yes, Judge, I think what we've agreed to do is have another visit between the three of us this afternoon. Mr. Stone has another hearing that he's got to get to. I think we've agreed to pass any ruling on the motions before the court at this time. And hopefully we're going to be able to figure out the bigger issues in the case in our visit this afternoon at 2 p.m.
Okay. So neither side's just passing the motions, not withdrawing them. So
That's right. It's just passing the hearings.
okay. All right. I believe that concludes this hearing. Thank you all.
Yes, Your Honor. I think that's right.
Thank you, Judge.
Thank
All
you,
right.
Your Honor. Have a good day.
You
Good luck
too.
with your home experiments.
Yes.
Thank you very much.
Thank you. There's somebody that's appeared through an identifying number as U87089. Can you hear me? If you can unmute yourself.
Yes, sir. That's me. I'm the Geico adjuster.
For which?
The bodily injury. Let's see. This is for
Alabuti versus Germania?
Canalo versus Sanchez.
Oh, okay. That one, they met and they've reached an agreement to pass the motion. So.
Okay. All right. Thank you so much. She
Okay.
just sent it. She just sent me an email. It was passed. Okay. Thank you,
Okay.
sir. All right.
Thank
Have a
you.
good day.
You
Bye-bye.
too. Yeah. It's not bulletproof. I've asked for that before, and that just falls in deaf ears.
Yeah, be careful of pool, you might be shooting yourself.
Yeah. That would be my. Yeah.
We could call it us thing behind it. Maybe just a wall. I know what I'm saying. You have a little bit of.
Yeah. You can't hear anything. Let me just get these signed and. Yeah, I don't know why people don't turn those lights on. It's so. We need all the light we can get in here because even when it's a bright sunny day, which it's not, but dark. Okay. Okay, let's go on the record and cause numbers D4029326. I'm sorry, D40923, D40925, and D40626. All style state versus Mary Elizabeth Farmer. I have States Counsel present, Defense Counsel, defendants present. Ms. Farmer, is that your full and complete name? Okay. And Ms. Farmer, it's the court's understanding that you're wishing to enter pleas of guilty to the offenses alleged in each indictment. Is that correct? And furthermore, you're wishing to enter a plea of true to the enhancement paragraphs that have been alleged in the indictments. Is that correct? And are you, do you understand what you're pleading guilty to and true to? Okay. That being the prohibited substance in a correctional facility, possession of controlled substance, penalty group 1, less than a gram, and then another possession of controlled substance, penalty group 1, less than a gram. All right. And Ms. Traden, you wish to waive readings of all three indictments. Record can so reflect. Ms. Farmer, in all three of these cases, I have documents that appear to have your signature on them. They're written waivers, written plea admonishments, a waiver of your right of appeal, judicial confession, and evidence discovery log there in each case. Did you sign these documents? Ma'am, did you have an opportunity to discuss these documents with your attorney? And he went over them with you. You completely understand everything you signed. You understand, ma'am, that you have a right to have a jury trial in each of these cases, and you're waiving that right. You also understand if you were found guilty by a jury, you'd have a right to have the same jury assess punishment. You understand that. Are you a citizen of the United States? And let me start. Cause number D40923, the prohibited substance is it was a third-degree felony, but based on the enhancement makes it punishable as a second-degree felony. You understand that? Anywhere from 2 to 20 years in Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range in that case? The 40925, sir, possession of controlled substance, penalty group 1, less than a gram. That is a state jail felony, but based on the enhancement and the habitual, it makes it punishable as a second-degree felony, anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range in that case? And finally, D40626, state jail felony, is punishable as anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range there? Now, it's my understanding in all three cases, ma'am, you've entered into plea agreements with the state through your attorney. Is that correct? Now, the court will not agree to be bound by the plea agreements that you've entered into. However, if the court follows the plea agreements, it cuts off your right of appeal except by permission of the court. You understand that? Are you entering your pleas of guilty freely and voluntarily and pleading true freely and voluntarily? And do you understand the consequences of your pleas of true? Your attorney is Mr. Hayden. Are you satisfied with his representation in all three of these cases? And Mr. Hayden, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise? Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered her pleas of guilty, that she understands the consequences of her pleas of guilty. The court will accept those pleas of guilty and find the defendant guilty should the evidence prove her guilty. In each case, I have states: 1, a judicial confession signed by the defendant, state seeking to have those exhibits admitted. Anything further? They're admitted. Anything further from either side? State have recommendations. I guess we can start off with 923.
There's also 85 days of credit. No fines or court costs on D40925.
So 5 years TDC on 925 and 923. And Mr. Hayden, on those two, is that you and your client's agreement? All right. Ma'am, in these two cases, the court will find you guilty based on the evidence, find the enhancement and habitual paragraphs to be true. It's the judgment of the court that you are sentenced in each of these cases, ma'am, to 5 years in the Texas Department of Criminal Justice Institutional Division. Court costs and fine restitution are assessed in the 923 cause number. Any reason why sentence should not be pronounced? In these two cases, ma'am, you're sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of sheriff, who will transport you to the appropriate facility, begin serving out these sentences. These sentences do begin today. You are given credit on these sentences as of today for 85 days. Any day thereafter, you're awaiting transport. So in these two cases, you waived your right of appeal. And state have a recommendation in the state jail felony. Ma'am, in this case, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court. You're sentenced to 7 months in a state jail facility. Any reason why sentence should not be pronounced in this case? Ma'am, you are sentenced to 7 months in a state jail facility. You are remanded to the custody of sheriff, who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 89 days, and any day thereafter you're waiting transport. It will run concurrently with other sentences you've just received. Furthermore, the court will make a finding that you are presumptively entitled to receive diligent participation credit if and when that's received by the court. Okay. All right, ma'am. Do you have any other cases pending? All right, ma'am. In this case, you've waived your right of appeal, and that concludes all 3 of these hearings. All right. Good luck to you, ma'am. Ms. Farmer, I'm going to give you something to take and review. I'll give you that. Ma'am, I'm going to look into these programs. It's basically the same thing. They've got some similar safety on keys. I can't worry you to it. I have to try Good luck. I'm sorry, did y'all have an opportunity to speak?
We did, Your Honor.
Mr. Polk, you'll have to unmute yourself.
Yes,
Okay.
Your Honor.
We'll go back on the record in 1 second. Okay, we'll come out of recess and cause number D19-28084-CV. And I think I put y'all in a breakout room to talk about the pending motions. And were y'all able to hash any of those out, or do you need hearings on all of them, or something in between?
Yes, Your Honor. We were able to agree to most of the motions in limine filed by the defendant in this matter. The only ones we weren't able to agree to were numbers 4, 7, and 13 of the defendant's motions.
4, 7, and 13?
Yes, Your Honor.
Okay.
And then Mr. Polk stated that the plaintiff did not file any motions in limine in this one. So these are the only motions that defendant is aware of.
Okay, well, let's take up those 4, 7, and 13 then, and then I'll make a note. All the other ones are agreed to?
Yes, Your Honor.
Yes, Your Honor.
All right. So, Mr. Polk, you, on behalf of your client, are not agreeing to 4, 7, and 13 of plaintiff's motion in limine?
Yes, Your Honor. Number 4, testimony from undisclosed fact witness, and my objection to it was we may have impeachment witnesses that I wouldn't have to disclose, and I don't. And his question to me was, who were they? And I said, you won't know that until I hear the testimony. It's just a matter of principle that we're entitled to impeach testimony if that becomes necessary.
Okay.
I don't know that I have one right now, but.
And Mr. Morris, do you have a response?
Yes, Your Honor. This is a UIM claim, so it's plaintiff versus an insurance company. We're not planning on calling any witnesses that would be impeached. Like, the only witnesses that we would question in this case are presumably plaintiff.
Okay, let me take that under advisement because I want to read the actual language in the motion. So I think I've heard the argument on that one. What about number 7?
Number 7, all statements calculated to inform the jury of the effect of their answers to questions. And my objection to that was, we always, during closing arguments, argue to the jury, we want you to answer question number 7, one way or the other, because. So I don't have a problem with, that would be part of the closing arguments. That was my objection to that.
Okay, so you're stating you want the limine keeps you from talking about the effect of their
decisions,
answers to questions?
Yes, in closing or especially in closing. I mean, that's what we do. We go over the charge with the jury and talk about the charge. At least that's what I've always done.
Yeah, I understand that part of it, but Mr. Morris, do you care to respond?
Yes, Your Honor. These are pretty standard motions in limine, and this one specifically is to prevent improper jury argument, stuff that would already be objectionable.
Okay. Again, I'm going to read the language of the actual motion so I can be a little better informed, but I understand what the arguments are and objections, so.
Yes, Your Honor.
Thank you. Number 13.
Number 13, any reference to any character or trait of character of the defendant. And he cites Rule 404. But Rule 404 says it's impermissible to use evidence of character to prove a particular person acted in accordance with the character or trait, but it gives all kinds of other exceptions that you can use character in a case. So that was my objection to that, is that I would agree not to use it to argue that anybody acted in conformity with a particular character or trait, but there are a number of exceptions under 404 wherein character is permitted. Character evidence is permitted to be used.
Mr. Morris?
Yes, Your Honor. Again, this is a UIM case against an insurance company. And if you read through 404, Your Honor, there are no exceptions that are applicable to this case, given the nature of this case. So while there are exceptions in 404 to use character evidence, none of those exceptions is applicable to this case specifically.
Respond to that. We won't know that until we get into the case, you know, to hear the evidence, I suppose.
Understand these are motions in limine, so let me read the actual language of the defendant's motion, and then I can make an appropriate ruling. Anything else?
No, Your Honor. No, that's on this motion in limine.
Okay. Were you able to get in contact with your client?
I have not received a call from him.
Let us press on forward for Monday. The motion to continue is denied. I'll have a panel here at 8:30. I'll go and do the qualifications, exemptions at that time, and then we can get into voir dire. This will be the first trial I've done and since January, February of 2020. So I may be rusty, but we'll try. I'll give each side 30 minutes for voir dire. Does that seem sufficient?
That was for defending, Your Honor.
I'm sorry?
Yes, I have no issues with 30 minutes.
30 minutes. Does either side wish to have some sort of warning, 5 minute, 10 minute, or?
Generally 5 minutes.
5.
Yes.
And we don't expect the defendant's voir dire to take that long, but we would appreciate a 5-minute break in the off chance it does, Your Honor.
It's not a break, it's 5-minute warning.
Warning. I apologize. Misspoke, Your Honor.
And I don't know what the response to this most recent summons will be. I've had 2 summons that have gone out for grand juries, and it's been quite responsive. And so we've always had enough for a grand jury, and so I'm assuming this will be the same. Those summons that went out for grand juries were during a time when the pandemic seemed to be really high, and so it seems like we're coming out of this. So we'll see. So we'll just hope for the best and keep hoping for the best. So I will make rulings on these 3 issues that are in dispute this afternoon and get them to you in writing, and then let me know if anything changes.
Thank you.
Thank you, Your Honor.
That concludes this hearing. See y'all Monday.
Yes, Your Honor. Thank you.